on 7/8/2022. Then
You take
Melidisa.
very good. Yes.
Then sketch is prepared on 20.
How are you aggrieved?
Well, see, we are the owners of the property. We have purchased it from the legal heirs of Melidisa. After the probate, my lords,
Huh.
there were two.
When did you purchase it?
In 2004, my lords, the registered sale deed, two registered sale deeds, my lords. It's produced.
Kindly see the will, my lord. It's of a Melidisa who died in Bombay, my lord. It's of Maharashtra. Somebody, there no mention of who is the husband's name is not there.
Let there be an investigation.
My lord, the question is, my lord, why should I?
I will answer the question. Why should you face trial?
No, I am just asking.
No
I
problem.
am just submitting to lordship
Yes, sir.
for consideration of lordship. Then I'm not telling. I'm just submitting so that
Okay,
my
sir.
lord
You
will
submit in
consider.
your own way. Don't worry about it.
My lord,
Yes.
this
I
Melidisa.
will not feel bad.
Yes,
Yes.
Melidisa is kindly see annexure R1 which they are producing. That is the
Death certificate of Melidisa.
Then, my lord, this is an unregistered will. If
Will need not be registered. Next.
yes, my lord. Then what is the property which is given to them? 37,789 square feet, my lord.
Of what?
Of property number 224 under survey number 3. They are mentioning.
What have you sold now?
My lord, she has sold me 3/4, my lord.
Of what?
Patandur village.
No. Survey number, sir.
Survey number 3/4.
Ah.
She has sold me in Patandur village, which is in his own sale deed is not his property, my lord. In his sale deed, kindly see,
Yes,
my lord.
ನಿಮ್ಮ survey number ಏನು?
My lords, it's sale deed is produced, my lords.
No, survey number
How-
ಹೇಳಿ sir.
Survey
It
number
is-
3, my lords.
Ah.
That time, my lords,
Allala,
it is a
our-
three. No doubt.
Property number 3, property number go, survey number go, vast difference. Your fake deed ಮಾಡೋರ್ದು ಇದೇ ಮೆಥಡ್. They will not.
ಯಾರು fake deed ಮಾಡೋದು?
ಇವರೇ
I
ಮಾಡಿರೋದು
am
fake.
alleging, my lords.
ಈಗ ಯಾರು ಮಾಡಿರೋದು fake?
ಅವ್ರು ಫೇಕ್ ಡೀಡ್ ಮಾಡ್ಬಿಟ್ಟು ನಮ್ಮ ಮೇಲೆ
In 2004.
ಫೈಲ್ ಕಂಪ್ಲೇಂಟ್.
ಅಲ್ಲ fake deed ಮಾಡಿದ್ ಯಾವಾಗ ಅವರು?
ಮೈ ಲೋಡ್
ಅಕಾರ್ಡಿಂಗ್ ಟು ಯಾವಾಗ? 2004 ಅಲ್ಲಿ.
2004 ಅಲ್ಲಿ ನಮ್ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ವಲ್ಲ.
ಕರೆಕ್ಟ್. 2004 fake deed.
ಹೌದು,
But
ನಮ್
ನಿಮ್ದು
ಸರ್ವೆ ನಂಬರ್
2022.
ಸರ್ವೆ ನಂಬರ್ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಹೋಗಿ ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಸರ್ವೆ ನಂಬರ್ ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ. ಇವ್ರು ಮಾಡಿರೋದು ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ 8.
See, my lords, after the FIR is registered, after police
Kindly
notice,
see,
they enter into a sale deed, my lords.
Anything else?
my lord, if it is only my only submission is it is not relating to my property
No
because only one before I'll
ನಾವು ಚಾರ್ಜ್ ಶೀಟ್ ಇನ್ನು ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ?
My lords, IR report is there, my lords. In the
Ah, it's
IR
already
report, they
here.
find out this Melidisa is not Melidisa. She has impersonated. She is someone called as Elizabeth Thomas, who shares the same name as the petitioner, who's Thomas before your lordship. And my lords,
ಇವಾಗ ನಮ್ kindly see my position, my lord. I have
Her
paid.
position very precarious.
Not my lord, that is my lordship, my
Yes,
lord.
sir.
My lord, I'm only kindly see the sketch which they have produced in their sale deed, my lord. It is according to him, there is a vacant land next to him. If
No, Gautam, you want me to answer? I will answer immediately on merit of the matter. No problem at all. You want me to answer? I'll answer. All your questions will be answered. Or you want to wait the charge sheet? You can wait.
my lord,
No
kindly,
case for interference at all.
my lord,
Prima facie.
my lord, it is better I face the judgment, my lord, so that.
Face the judgment.
Yes, ma'am.
Perfect, sir. Yes, thoroughly.
my lords, sorry.
Yes, sir. Tell me.
My lords, in the agreement of sale, which has been entered by a impersonated Melidisa and the petitioner, at page number 39, my lords, of the petition, the petitioner states in a registered document that he has issued so many checks. None of these checks, the sale consideration and these 7 to 8 checks are mentioned in this very own passbook, my lords.
My lord, they have taken wrong account
Clearly-
number, my lord, and he is
No.
based on
No problem.
account number ಬೇರೆ ನಂಬರ್ ಕೊಟ್ಟು
ಪರವಾಗಿಲ್ಲ sir. ತೊಂದ್ರೆ
ಅದನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟು
ತೊಂದ್ರೆ ಇಲ್ಲ.
I only request your lordship, my lord, kind for one more I am for the sake of repetition, I will not take even one more minute, my lord.
Take, sir.
Kindly see the sketch, my lord, with the akar band that is prepared by the revenue officials. It is very clear it is not his land, my lord.
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿಲ್ವಾ?
ನಾವು
ಹಾಕಿಲ್ಲ.
ಈಗ
They are in
ಡಿಕ್ಲರೇಷನ್
They will
ಇವಾಗ
not-
ಅವರು ಡಿಕ್ಲರೇಷನ್ ಹಾಕ್ಬೇಕು, ಅವರು ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಬೇಕು.
ಡಿಕ್ಲರೇಷನ್ 2004 ಅಲ್ಲಿ ತಗೊಂಡಿರೋ ಪ್ರಾಪರ್ಟಿಗೆ ಅವ್ರಿಗೆ
ಅದು
ಈಗ
ನಮ್ದಲ್ಲ.
Khata is in my name.
It is not our property at all. Lease taken some other property. ತಾವು ಈ ಸ್ಕೆಚ್ ನೋಡಿದ್ರೆ ವೆರಿ ಕ್ಲಿಯರ್ ಗೊತ್ತಾಗುತ್ತೆ.
Yes, sir.
ಇಲ್ಲಿ ತಾವು ಪೇಜ್ ನಂಬರ್ 84 ತಾವು ನೋಡಿ ಸರ್. ಇಲ್ಲಿ ಮಿಲ್ಲಿ ಡಿಸಾಗೆ ಇಲ್ಲಿ ಅವರು ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. For Millie Desa's property, it is mentioned clearly, my lord, which is allotted to her.
Madam,
Unique Saldana anta.
Judgments ತರಕಲಿ ಅಂತ ಹೋಮನ್. ಸುವೇದ್ಯಾಗ judgments ತರಕಲಿ ಅಂತ ಹೋಗ್ತಾರೆ.
My lord, page number 85 ಅಲ್ಲಿ first part, there is a vacant land, my lord. That is Millie Desa's property. Fourth part is also Millie Desa's. ಈ number 3 and 2 ಇರೋದು ಯುನಿಕ್ ಸಲ್ದಾನ ಅದು. They trace their title from Unique Saldana. It is not Millie Desa's land. So this property is allotted to me as per the agreement. So totally different properties.
Okay. Yes. The petitioner, accused number 1, is knocking at the doors of this court and the subject petition, calling in question registration of a crime in crime number 204 of 2023, registered for the following offenses. Heard so and so. The petitioner claims to be an agreement holder of a property which is allegedly owned by one Millie Desa. The agreement with regard to the subject property is entered into on 12th December 2022. The property is also claimed by the complainants. Therefore, the complainants register a crime in the crime number so and so, register a complaint which becomes a crime in crime number 204 of 2023 for the aforequoted offenses. Registration of the crime has driven the petitioner to this court in the subject petition. The learned counsel Gautam Dev Ullad submits that the property that the complainants claim and the property that he has entered agreement into are entirely different. Millie Desa has herself appeared before the sub-registrar and has registered the agreement in favor of the petitioner. The learned counsel, by taking this court through the documents appended to the petition, would seek to demonstrate that the survey number is entirely different, and what the complainants claim is Millie Desa of Bombay, who has died in the year 1991, but Millie Desa appeared before the sub-registrar and got the agreement registered in favor of the petitioner. The learned counsel would submit it is at best a matter which has to be agitated by the complainants before a competent suit for declaration and not setting the criminal law into motion in a case which is purely civil in nature. He would contend that the petitioner should not be made to face the criminal proceedings without any rhyme or reason. Per contra, the learned counsel representing the complainant would take this court through the statement of objection so filed by the complainant to contend that Millie Desa died in the year 1991. The property that she held was bequeathed and the will was probated before the competent court at Mumbai. After the probation of the will and long thereafter, by a registered sale deed, the complainant purchases the property from the hands of the legal heirs of Millie Desa by way of 2 sale deeds and are said to be in possession of the property. And he would therefore submit that who is the Millie Desa who came before the sub-registrar at Bangalore should be investigated into, and that is what the investigation is all about. The learned HCGP has placed the papers of investigation conducted till date before the court for its perusal. I have given my anxious concerns so and so. The afore narrated facts at this juncture would lie in a narrow compass. The history that is narrated in the petition dates back to 1960. The 1960 and a sale deed of the year 23-3 2004, which is said to be executed in favor of the complainant by Millie Disa. Oh, sorry, by the legal heirs of Millie Disa. Sale deed, correct. Two sale deeds executed by same day, alva, by the legal heirs of Millie Disa. Millie Disa owned the property. The Millie Disa had executed a will which comes to be probated by the concerned court before in Mumbai, by which the vendors of the complainant come into the picture as their legal heirs in terms of the will so executed. Therefore, the death certificate produced by the complainants as annexure R1 to the complaint, R1 to the statement of objections, would depict that Millie Disa died in 1991 and the complainants have been in possession of the property. The learned counsel for the petitioner tries to make a feeble attempt with regard to depiction of the survey numbers of the sale deed of the complainant and the agreement of sale entered into with in favor of the petitioner. The submissions are noted only to be rejected. As the court is exercising its jurisdiction under section 482 of the CRPC and cannot conduct a roving inquiry into seriously disputed questions of fact in the case at hand, as the allegation is impersonation and forgery. Impersonation of a person who died in the year 1991 and appearance of the same person before the sub-registrar at Bangalore in the year 2022. Therefore, these matters are to be investigated into. A given fact can spring into two proceedings. One, a civil remedy, a civil wrong or a civil remedy to be initiated, another criminal proceeding. It is no law that merely because certain cases have a flavor of civil law, the criminal law cannot be set into motion. This forms a classic illustration of the said observation by the apex court in plethora of judgments. One of I deem it appropriate to quote the judgment of the apex court in the case of Kamal Shivaji Pokarnekar, 2019-14 SEC, page 350. The apex court holds when the case projected before the court exercising jurisdiction under section 482 of the CRPC is shrouded with seriously disputed questions of fact, the court would not interfere. The facts in the case at hand are a maze, and it would amaze this court for interference. Therefore, therefore, the petition lacking in merit stands rejected. Yes.
Number 10.
Hearing for the petitioner, my lords. Petition has been preferred on two grounds. One, initiation of criminal proceedings itself is an dispute.
Order, sir.
Orders, lords.
10, sorry, sir. Second list. Holding the first list. Yes, sir.
Petition has been preferred on two grounds, my lords. One, initiation of criminal proceedings is an abuse of process of law.
Yes, sir.
Second is flaws in the order of cognizance calling for interference by his honorable court.
Yes.
Now, the allegation against me is that on May 28, 2020, I have sent 24 emails from my official email ID to my personal email ID that contained company confidential documents and which was discovered the next day, May 29, 2020. Now, on May 29, 2020, I have voluntarily handed over my personal laptop, my mobile phone, and my Google Mail credentials to prove my bona fides. Now, after this, on September 24th, 2020, almost 4 months later, a complaint is filed alleging offenses under the IT Act, sections 66, 66C, 72A, and also cheating. Now, no preliminary inquiry is done. FIR is registered on the very same day.
Anyway, B report ಹಾಕಿದ್ರಲ್ಲ ಅದಕ್ಕೆ ಯಾಕೆ ಹೋಗ್ತೀರಾ?
B report has been rejected.
That is why do you go before travel back and say preliminary inquiry is not done? They filed a B report in newspaper. Yes.
Second, a civil suit is instituted on October 22nd. There is an order of injunction against me wherein I'm restrained from disclosing company confidential material to any third parties. That is in force now. Now, civil suit was filed after the complaint has been filed. So the basic premise would be that the allegations in the plaint and the complaint should be more or less the same. I will point out the embellishments that have been made in the complaint vis-a-vis the plain to make out a complaint. Kindly come to page 158, my lords.
Data theft is the allegation?
Yes,
All right. 150?
158, my lords. This is the plain,
Yes.
para 4.17. On 9/7/2020, the KPMG gave its final report with detailed observations and the suggested course of action. In terms of the said final report, KPMG came to the conclusion that the defendant copied the 24 emails from the official email address to his personal email address. The said emails have not been forwarded and that there were no deleted emails. These findings were from the personal email address of the defendant.
Yes.
Kindly come to page 83, my lords. Para 6.
Yes.
It was also confirmed by KPMG that on May 28, 2020, one day prior to his resignation, Rahul Pandya had indeed sent 24 emails from his official so-and-so ID to a Gmail ID, as was also found by the company's internal team in the earlier. In the said batch of emails sent on May 28, 10 emails were from so-and-so and so-and-so. Here, they don't mention the fact that KPMG has also reported that these have not been forwarded to anyone and there are no deleted emails. Now, please come to page 87. So this has been deliberately omitted in the plaint. Kindly come to page 87.
Plaint.
Plaint in the civil suit.
Why are you on that?
The reason is the plaint is filed after the complaint. They don't disclose in the plaint that these have not been forwarded to anyone and that there were don't deleted emails. This is one.
All right. Copy paste madad bekagilla.
Right. Next, para 10, your lord, on page 87. Fifth
And
line.
Yes.
I'll read out. It is crystal clear that Rahul Pandya was not just cheating the company on almost a daily basis, but possibly also had fraudulent intentions to steal valuable confidential data / proprietary information of the company from day one and possibly even before joining the company. And prima facie appears that he joined the company only with the sole motive to commit the aforesaid offences of criminal breach of trust and cheating, in addition to offences committed under the Information Technology Act 2000. Now, illy, notwithstanding the fact that I've undergone a technical interview, cleared it, a HR interview, cleared it, a third party has been engaged to verify my educational credentials. Every company that I work for, the dates have been verified, reference checks have been done. Only after a clean sheet is given by the third party, only then an offer of employment has been made to me. Notwithstanding all this, these stigmatic allegations are made to make out the offense of cheating.
Idu Zetwork complainant. Zetwork is a complainant?
No.
Oh, because he. Yes, sir.
So these stigmatic allegations are made. Now, it is also yeah, and also in Delhi Race Club versus State of UP and others.
Sir, what is 406? What is 420?
Yes,
separate?
and also that for the same set of facts and circumstances, both cheating and criminal breach of trust cannot be made out.
Correct.
Here, to make out cheating, they have imputed that, I joined with the intention of teaching, which is not the case. And these are stigmatic allegations.
Sheet hakidara.
Charge sheet hakila, B report hakudru.
B report hakadru.
Yeah.
ಈಗ cognizance ಯಾವ್ದಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ?
66, 66C, 72A, and also 420.
All right.
I'll come to that also, my lords. Now, it is a civil dispute, is my contention.
ಅಲ್ಲ ಇದು ಆರ್ಡರ್ ಆನ್ ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
Order on B report either cognizance has been taken and it has been posted for sworn statement of the complainant.
How did you get to know?
Huh?
How did you get?
I filed an application under 452 seeking a return of my mobile phone, my laptop.
Oh, then you got to know.
Yes.
Yes.
Now, in between this 4 months, a disciplinary inquiry is also done.
Disciplinary inquiry.
Yes.
By whom?
By the complainant.
Samsung.
Yes.
Oh.
A show cause notice is issued to me.
ಅದರಲ್ಲಿ exonerate ಮಾಡಿದ್ದಾರೆ ನಿನ್ನ.
ಇಲ್ಲ ಹೇಳ್ತೀನಿ ಅದನ್ನು. Kindly come to page 133, my lords.
133. Where is the order on summons? Nothing.
Someone's issue ಆಗಿಲ್ಲ.
Issue ಆಗ್ಲಿ ಆಮೇಲೆ ನೋಡಿ ಕೇಳೋಣ.
ಅಲ್ಲ, let me point out. Initiation of criminal proceeding itself is what I'm calling for interference, my lords.
ಈಗ B report is rejected and cognizance is taken. Anyway, it's not maintainable ಅಂತಲ್ಲ. It can. But let the court issue summons.
May I point out, my lord, that this is a civil dispute? Kindly come to page 133, my lords. The 5th paragraph. Accordingly, as a matter of natural justice, company hereby gives you a chance to present your narrative facts, etc., etc. In that same paragraph, it says, if in any case you have nothing to add or substantiate and you accept your fault, you may prefer a written apology and admission of fault by way of written communication addressed to the company within 3 working days. So, disciplinary inquiry show cause notice kottaga, I'm also offered the option of giving a written apology. I attend the disciplinary proceedings. I also give a written submission. Kindly come to page 144, my lords. This is the minutes of meeting of the disciplinary inquiry. In this, my lords, there are only two documents. There are only two documents. One is the show cause notice. Second is the apology letter. I am not confronted with any evidence to show that I have misappropriated or I have stolen data. Except,
You want me to give a finding on everything?
I mean,
Will give.
if my lords has made up his mind, then I will.
Made up, illa, sir. Don't give these old style arguments. If my lords have
I-
made up my mind, I will not submit. We are in a dialogue. Yes.
Then can I come to page 71, my lords?
Yes, come. Yalla, if my lords have made up my mind, I will not submit any further. All new judiciary, sir. Yes, come up
Page-
with new things.
Page 71, my lords.
Yes.
This is the order of taking cognizance.
Page?
71.
Huh.
Mere transferring the confidential data of another person or company without their permission itself amounts to an offense under the Information Technology Act 2000. This is the finding. Now, section 66, the first section that I'm charged with, it starts with if any person dishonestly or fraudulently sends information. So intention is paramount here. Here it is held that, intention is not at all required. This is one. Section 66C, that is for identity theft. I have not stolen anybody's identity.
So
I
now
have-
66, 66C, 72A and
72A.
420.
Yes, 72A also, my lords, it is for breach of disclosure of information in breach of lawful contract. It is for between an intermediary or a service provider. It is not applicable to this case. And last is 420, wherein they have imputed intention to me even before I joined, wherein they have thoroughly verified my background. Only after that they have made an offer. And I've also given a written apology. I have submitted to them n number of times saying that I have not forwarded any company confidential to anybody else, etc. So in spite of all this, criminal proceedings has been initiated. Now, also, they claim that they have evidence that I have actually done something wrong. Kindly come to page 93, my lords. May I read out, my lords?
Yes.
ದಿನಾಂಕ 19/1/2023 ರಂದು ತನಿಖಾ ಸಮಯದಲ್ಲಿ ಶ್ರೀ ಸ್ಟಾನ್ಲಿ ಫ್ರಾನ್ಸಿಸ್ ಅವರು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ HR ಪಿರ್ಯಾದಿರವರು ಆರೋಪಿಗೆ ದಿನಾಂಕ 29/5/2020 ರಂದು ದತ್ತಾಂಶಗಳನ್ನು ಡಿಲೀಟ್ ಮಾಡುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಿರುವ ಮೇಲ್ ಪ್ರತಿ ಮತ್ತು ದತ್ತಾಂಶಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಸಾಕ್ಷ್ಯಗಳನ್ನು ಹಾರ್ಡ್ ಡಿಸ್ಕ್ ನಲ್ಲಿ ಸಂಗ್ರಹಿಸಿ ಕಾಲಂ 65B ಪ್ರಮಾಣ ಪತ್ರದೊಂದಿಗೆ ನೀಡಿರುತ್ತಾರೆ. ಅವುಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ಕೇಸಿನ ಕಡತಕ್ಕೆ ಅಳವಡಿಸಿಕೊಂಡಿರುತ್ತದೆ. Indeed, if they had this whatever evidence against me, they could have filed it along with the complaint. They need not have waited for 2.5 years to go and give it to the police. These are my points, my lords.
All right. Yes, sir.
That was seized from him is incorrect. May I just request your lordship to kindly turn to page 64, the order at paragraph 12. But what he does is, no sooner the B report came to be filed, he would gate crash into the court and says, no, hear me, don't accept the B report. He has no locus at that point of time. Have a look at paragraph 12 at page 64.
Accused has appeared through his counsel and prayed to hear him on B final report. All right.
The trial court grants it.
Hears him also.
Yes, hears him also.
Hmm.
Well, then the order of cognizance is passed. The court is still to record the sworn statement. The court is still to pass an order under section 204. It has still got to come to the conclusion that existence of sufficient
Anyway,
grounds.
we'll answer whatever his contention is.
ಒಂದು ಅಲಹಾಬಾದ್ ಹೈಕೋರ್ಟ್ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಮೆಂಟ್ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ otherwise I can certainly understand the law being fairly well settled, that if there is a prohibition imposed upon the court in the matter of taking of cognizance for certain reasons, despite those reasons being not available, if the court were to take cognizance, then it is always open to the accused, my lord, to approach this court and question the legality and correctness of the order of taking
No,
cognizance.
he is your employee earlier. Has he done this actually?
ಅಪಾಲಜಿನಿ ಇದನ್ನು ಮಾಡಿದ್ದೀನಿ ತಪ್ಪು ಅಂತ.
Where is the apology?
Yes, my lord. May I request your lordship to kindly turn to?
Page.
Yes, my lord. And even in fact, the civil court also would take note of it and grants an order of injunction. Page
Where-
119.
Page?
119 of his document. Why the court would give a I mean, why the police would give a B report is for this reason. In his laptop, it has been erased, it is not there. If it has been erased, it is not there. They have got to get it retrieved.
Why have you accepted, sir?
And then he,
Okay. Though we are not supposed to go into my defense is,
Sir,
Alala,
I am asking you, why have you accepted the guilt?
he has stolen.
may I explain, my lords? The reason is
Confidential
that
information.
they were not allowed to take the official laptop home. He says that he has been working on
Defense.
training material back at home. And he has done this earlier also. He has never forwarded to anyone. In fact, they rely on a document which I have signed and which I also admit that I've signed. The only contention is they say that I have violated it. I say that I always avoided by it. Kindly come to page 106, my lords.
There are defense documents.
Allah, it is the document that they rely on.
Wait,
Your-
wait, yes, sir.
But,
Very-
in fact, your lordship posed a question whether he could question the legality and correctness of the order of cognizance. In fact, a full bench unless and until there is a prohibition under law for the court to have taken cognizance. Kindly go to paragraph 81 for a second. Otherwise, every accused will go before the court. No, well, cognizance is nothing but acceptance of the complaint for the purpose of recording further proceedings in the case. Then the accused will rush. No, don't record further proceedings. Kindly go to
No, no,
paragraph.
that may not be. You have no right to go there and
What is it?
stop. Then
Can't stop.
As my
not
lord has-
stop or whatever. You have no right
The
of
Lord has
audience
pointed
at that stage.
But he gets the right or the authority or the jurisdiction to question only when an order under section 204 is passed. Not till then at any rate.
That we'll see. Yes, Ashtana?
Kindly come to page 106, my lords. This is the confidentiality protection agreement,
Mm.
which they rely on. They contend that I have signed it, that I am bound by it. I also contend that, yes, I have signed it, I am bound by it. The only dispute is respect to, they say that I have violated it. I say that, no, I am covered by it. Para on page 106, my lords, confidentiality clause 1.1.
Mm.
At all times during the employment thereafter, the employee shall hold all company confidential information in the strictest of confidence and will not directly or indirectly, whether by himself or through some other person or entity, disclose, use, copy, publish, lecture upon, summarize, or remove from the premises of the company any confidential information or permit the same to be done, except as is necessary to carry out the employee's assigned responsibility as an employee of the company or as permitted by a duly authorized officer of the company. Now,
Yes.
my defense is that in good faith and with bona fide intentions, I have transferred this, I have worked on this after office hours. This is my defense. Since they are relying on this, I am also saying this.
All right. Yes.
Also, lastly, my lords, the gravity of the punishment, the quantum of punishment should be commensurate with the gravity of misconduct. Here, for the last 4 years, I have been dragged through the civil proceedings, the criminal proceedings, etc., wherein a B report has been filed. I have cooperated in the investigation conducted by the police. I have voluntarily surrendered my personal laptop, mobile phone, Google Mail, user ID,
So
password.
you're in custody now.
I'm not in custody, but the social stigma attached, my lords, when the police had come home-
That will go after the case, sir. Yes. Yes. List on 26 for dictating orders. Next.
Grateful.
Our argument illa.
Aye.
Yes. Next.
11.
This is the NDPS case and allegation of the possession of 100 grams of ganja. And primary ground that I urge,
It's conducted, my lord, that the inventory is there, certificate is also there.
and my contention is that
Inventory is there.
Yes,
here the contention is that law, the non-compliance of section
52,
52A as well as the
50.
Yes.
Yes, sir.
Lord.
50 is, possession is not from his physical, but notice has also been issued,
Possession is not from the body.
not from the body, from the vehicle.
Lord,
All right.
as-
Amal 52A.
The
Compliance idea.
Lord, the
inventory is, there, certificate is also there to the
No, before whom?
magistrate.
Yeah, the case is that Lord 50 is concerned, Lord, the item was recovered from the bag admittedly. But as well as the
Bag, illa.
personal search of the person was also conducted.
You see the judgment of the Supreme Court.
Yes, my Lord, in the
Not from the
Section
vehicle.
50, even from the bag, it is,
covered.
Bag is the extension of the body, that's the argument
Ah.
was placed. Supreme Court said that it's not an extension of body and 50 is not required if it is extension of, if it is the bag, record from the bag.
that's-
In any case, here also, my lord, notice has been issued to him. He accepted that it has to be,
yes, we'll see.
Yes.
Let it come. List in the second week of October. Yes, next.
12.
The learned additional SPP has complied with the order dated 4/9/2024. Therefore, list the matter in the third week of October. Next.
Three 399,402, my lord, split up charge sheet.
Wednesday, fresh matters list, yes. In custody ಇಲ್ಲ
No, my lord, he is not.
next.
Three matter may kindly wait.
ಇದೆ ಅಲ್ವಾ? Entry order subsisting shall continue to the next date of hearing. ಮತ್ ಬರ್ಲಿ ಬಿಡಿ ಆಮೇಲೆ. This list after vacation, next. 13.
13.
The charge sheet is sought to be quashed.
PF,
Offense under,
PF to R2.
I have paid, my lord.
ಯಾವಾಗ?
I have paid, my lord. I'm
When?
sorry, my lord, on the last date, my lord, was under the impression that the order is only for the, to the learned government advocate.
Emergent
So
notice to second respondent ಇದೆಯಲ್ಲ?
I have paid the process, my lord. It is paid.
Let the complainant come then. Yes. Put up immediately after the receipt of the notice to the complainant. Next.
Great.
14. MMDR. 14 is MMDR, my lord.
ಆಯ್ತು, ಇದು ಮುಗಿಸ್ಕೊಂಡು ಪಾಸ್ವರ್ಡ್ ಮಾಡಿರ್ತೀನಿ, ಆದ್ರೆ ಇವತ್ತು ತಗೊಂಡು. Yes, next.
15.
For the petitioner, my lord. Last time, your lordship had directed the police to say, PP to secure the police records.
Please, my lord.
ಕೊಡಿ.
The petition is filed by the mother. The husband and wife dispute, my lord. There are no, absolutely, there are no allegations against the mother. And 307 and 376 is also charged. That is,
376, that is
70.
not against the mother.
yes, my lord. Even
You are accused number
307
2.
Yes, my lord. 307 is also not against the mother.
Where is the complaint?
Complaint is at, it starts at page 20, my
Put him
lord.
at-
Typed copy is at 24, my
ಒಂದು
lord.
ನಿಮಿಷ ಕೊಡಿ. Today night vomiting 3 times. Yes, madam. Husband ಹೊಡೆದಿರೋದು. Yes. The learned HCGP was directed to secure the investigation papers. A wound certificate is appended to the investigating papers, which is, in which the complaint is against the husband. A perusal at the complaint also is against the husband, as what is narrated is the accused number 1 picked up a knife in order to, in an attempt to kill the complainant. Therefore, all the offenses are against the husband, who is also alleged of section 376 of the IPC. The petitioner before the court is the mother or the mother-in-law of the complainant. Finding no allegation or ingredient of section 307 even on the perusal of the investigation papers, I deem it appropriate to stall further investigation qua the petitioner accused number 2. It is made clear it's made clear further investigation or proceedings against any other accused is not stayed.
Much obliged.
Yes, next. ಇದು ಕೊಟ್ಬಿಡಿ ವಾಪಸ್.
16. MMDR.
Password, wait.
17.
Yes,
My
Amar.
lord- My lords, I appear for respondent number 2 in this matter, my lords.
May please, my lords. Look, the matter had come up on 27th, and when it came up on 27th, even before notice was ordered, they would enter appearance, and it's posted today for the consideration of the interim order, my lords.
What's the matter?
A disgruntled employee, my
With
lords.
great respect, I want to correct my learned friend. He was not there on the last date. My lords
He
had
has
in
been
fact
briefed.
said, yes, that I have no doubt. But my lords had in fact said that there is no grounds made out for interim order. We were asked to file a reply,
My
which
lords,
we
could I
have
make my
filed,
submission?
and
My
full
lords,
matter
are they
to be
against
heard.
me making my submissions, my lords, if I make out a case? My lords, a disgruntled employee, my lords, who when put on a program, my lords, because when she was taken in, she was not up to the mark even as per the assessment done in US, my lords, which is a parent company. So they would put her on a program. Now, because she's put on a program, my lords, she starts sending mails not only to the officials here, but also to the officials in US. Now, kindly notice, my lords, the mail that she sends, please notice at page 43, annexure D, my lords. It commences on 2nd April 2024. From US, my lords, they write as to how she has not been up to the mark and therefore she should undergo a training program. My lords should get annexure D, page 43. 2nd April 2024.
Hmm.
My lords, they point out what they found as a flaw in her work. Now, this is communicated to her, page 41, my lords.
1 minute, 1 minute. This
Please,
is
my
dated
My lords, this dated 2nd April
2nd April
2024.
24.
Please notice, my lords, at page 41, that is communicated to her. And my lords, kindly notice in the bottom, they say, please take the above feedback positively and work towards them. She's still not put in that PIP program, my lords. She gets put into the PIP program on 11th April, my lords. The program is to enhance her performance.
Where is
Now,
that?
my lords, that happens on 11th April.
Where do I get that?
My lords, we have it in a memo when she's been put into it.
Then
Then, my
That
lords,
has not been served to us, my lords.
could I just
I'm
out the
sorry.
documents? They themselves in their objections say that. My lords, post that, my lords, kindly notice page 89. So 11th, she's put on the program. Now she has a grievance against it. My lords, after she's put on program on 11th, 12th, she accepted it. On 17th, my lords, what transpires is at page 89. My lord, she finds fault with her being put into the training program, and she writes this email to about 250 persons, my lords. My lords would get that at page 89.
yes.
And the persons she addresses it, we get it from page 85 onwards, my lords.
Right.
Now, post this, my lords, after this happens, she would, my lords, write to the officials at US at page 126, my lords, which was on 18th April. 18th April. Please notice at the bottom, my lords, she would say, all the way I took blame in terms of so and so and so. I should protect my rights professionally, ethically, and legally. My lords would notice at page 126. Post that, my lords. After doing that, please notice what transpired on 18th. A series of mails which she writes to the various officers concerned, my lords, which we get at page 226, my lords, 18th April. She would say that she'll go to the labor court.
Prepare a list of dates.
Yes, my lords. This is the last date.
happened on what date?
This is the last date, 18th April.
Prepare a list
Yes.
of dates. What has happened on what date?
Yes, my
I'll
lords.
take this on Tuesday.
On Tuesday, my lords.
My lords,
मेरी लाइफ पार्टनर साक्षी तो है मिसिंग, बट मेरे घर की शाइन सबसे बेहतरीन। गिव योर होम एन इंडिगो इंटीरियर शीन इमल्शन मेकओवर, झकास फिनिश at an affordable price.
Video editing is hard, and it takes away your precious time. Don't be like this guy. Just use video.